That is the amount of distance between this being an aggravated assault and a murder. 4 inches. This man shot an unarmed 17-year-old in the face. The only reason I'm in here is because of ballistics. That is not a person that is apologizing and taking responsibility. That is a person who is upset he got caught.
The court is going to find you guilty.
In the dark, pre-dawn hours, a dispute over bad driving escalated into a terrifying road rage encounter between the defendant and Jalen, an unarmed 17-year-old boy. During the altercation, the defendant shot the teen point blank in the face. Prosecutors hammered home a chilling fact. Had the bullet struck just 4 inches higher, this would be a murder trial, and the teen would have been left dead on the side of the road. Instead of calling 911, the defendant fled the scene and even cleaned the weapon in a desperate attempt to destroy evidence. It ultimately took forensic ballistics to track him down and bring him to justice. Recorded jailhouse phone calls revealed a disturbing lack of remorse. Rather than showing guilt, the defendant blamed the victim for putting himself in harm's way and only expressed frustration over getting caught. The defense argued for leniency, pointing out that the defendant had a clean record and had already spent 10 months behind bars awaiting trial. But the prosecution vehemently opposed the defense's plea for probation, calling the crime absolutely heinous. Surviving that single gunshot forced the victim to undergo a grueling 6 surgeries, leaving his entire family devastated. The state is now demanding the absolute maximum sentence allowed, 25 years for assault with a deadly weapon, insisting that even 20 years would fall short of justice. Welcome to Justice Judged. Let's step inside the courtroom to see how Judge Boyd will rule.
More importantly, I think we can tell from the conversations with my client and the previous gentleman that there was a lot going on that morning. I mean, first, if you read the reports, he passes him and slows down to take a picture. If you hear today, he drives off and then slows down so he can catch him. There's a bad driving on everybody's part, perhaps. But I do know that, my client, as he's told the court, feels terribly about what's happened. He did not intend for this to be the result of his actions. However, it is the result of his actions. He has applied for deferred adjudication. He would certainly like you to consider that application. I would bolster that consideration with the fact that he's never been in trouble for anything. Now, in the event that the court denies his application for deferred adjudication, then I would certainly ask the court, when considering the range of punishment, to look below this 25-year cap. I certainly don't think that in this case, with these facts, that number is attributable to what happened, if you will. Once again, he's never been in trouble. He was part of a incident on the roadway that both of these cars were involved in. Both of them were sticking things out of their cars. I do believe that at that time of the morning, it was still pretty dark out. I think he's an excellent candidate for deferred, but if you do not give him deferred, I ask that you consider the lower range of the punishment. He has been in jail 10 months, almost 10 months, waiting for this day. All right, that's all I have, Judge.
State.
4 inches, Judge. That is the amount of distance between this being an aggravated assault and a murder. It's 4 inches. If that shot had been higher than 4 inches, Jalen wouldn't be sitting here. He would have been left by Arnold Benya on the side of that highway to die. And even more so, Jalen wasn't even armed. They searched the vehicle. This man shot an unarmed 17-year-old in the face and has the gall to ask, give me deferred so I can walk right on out that door. Even more so, he says that he's justified, but he doesn't do anything to show that he was in the right. He covered this up. He never told anyone. He never told 911, and the gun was cleaned off. And he said he didn't do anything with the firearm, and he put it away a day afterwards. That is impossible without some kind of tampering by Arnold Benya. And further, Judge, I want to go to page 13 and 14 of Sean O'Neill's report. This is in stipulated evidence, and it goes into admissions that the defendant made on his jail calls. And I quote, referring to Jalen, he put himself in danger. At the end of the day, I did what I did, right? And I took off first. They got me with this shit because they took ballistics on my gun when they took it. And that's the only reason why they pretty much know what happened. The callous disregard of he put himself in danger. They wouldn't have caught me if they had done all of this. The only reason I'm in here is because of ballistics. That is not a person that is apologizing and taking responsibility. That is a person who is upset he got caught. I know that Mr. Benya is talking about his 17-year-old, now 18-year-old stepdaughter. Jalen, 17, 18-year-old, is 18-year-old as well. And he's going to have to deal with what Mr. Pena did for holding up a phone for the rest of his life. So, Judge, I am absolutely vehement that deferred is well below what should justice be done here. 5, 10, 15, 20 years is well below what justice requires here. Justice requires that the cap all the way 25 years with the finding of deadly weapon be applied in this case. And that is what I'm going to ask you to do, Judge, to sentence him to the cap, the maximum 25 years with a finding of deadly weapon.
Right. And do parties agree that the amount of restitution is $4,987.42? That's what's in the PSI report.
I agree that's what's in the PSI. I can't straight for the veracity of that number, but that's what's in the PSI report.
All right.
4987.42.
And Judge,
So, yes.
I would have to discuss that with Lisa and Jalen about if that's the proper amount. Because I can't, with 6 surgeries, it has to be higher than that.
Okay. Norma?
Yes, sir.
Recall this. He's going to recall this in 30 days with regards to the restitution. Is that enough for everybody?
Yes, Judge.
Absolutely.
All right. What date?
So May 20th? Oh, no. You said
Sorry.
June. You want to do the June 8th?
Yes, please.
June 8th.
All right. So we'll address the issues of restitution on June 8th. This is what I want you to realize. One, I read everything. I keep an open mind about everything. And I look at the facts, basically what's in the stipulation, and I consider all the testimony that is given to me. And I understand that you have 0 criminal history, right? So I take all of that in consideration, all the evidence that's presented to me. Okay. So this is what the court is going to do. The court is going to find you guilty, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. There's to be restitution hearing on June 8, 2026. There's an affirmative finding of deadly weapon, and the court will sentence you to 15 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I would like to address that.
Yes.
Yes, at the time he signed it, he had no rights to appeal, but having had the motion to withdraw the
Yes.
plea, I have, and I'm going to tender to the court a notice of appeal specifically on that issue. So
Right.
I
And could you
don't
do me a
believe that
favor? Could you, because the trial court certification, I think, was
we get a
originally,
different one.
yes,
I would prefer that if you don't mind.
yes, because that was originally signed by Judge Angelini because he took the plea.
Okay.
All right. All right. So the trial court certification of defendant's rights to appeal, you do have a right to appeal that's related to any type of pretrial motions that were heard and that were ruled upon. And you did have pretrial motions in this case that were heard and ruled upon by me. The motion to withdraw your plea being one of them. You understand?
Yes, ma'am.
Okay. Now, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Okay. And so we'll be back on June 8th to determine restitution amount. Your attorney will be given information on what the state is proposing restitution be. And if y'all can't reach an agreement on that, I'll make a decision, okay? Thank you.
And Judge, at this time, I'd like to tender to the court if I could. First, the notice of appeal on my client's behalf, and then secondly, my motion to withdraw solely so the court can appoint him an appellate attorney to handle.
All right, so,
But I'll stay on for the purposes of the restitution hearing. I don't want to delay his appellate rights. Since he's been sentenced today, the
Yeah.
clock starts, so
Yeah.
maybe you can make my notice effective June the 8th or something.
okay. And can I have the trial court
Oh, I'm
certificate?
sorry.
That's okay. What's that? And Norma? Yes. Oh, there's no order, but Norma appointed appellate attorney and see if that appellate attorney can be here on June 8th, whoever it may be, so that you'll have a chance to speak with them at that time.
Thank you.
And then your motion to withdraw,
Just hold
We'll
on
deal
to
with it
till the
after
8th.
that, yes.
That's fine. Thank you.